Absolutely shocking events unfolded inside a federal courtroom in early January 2026, and what happened was not merely a legal dispute, it was a direct collision between judicial authority, political power, and raw institutional defiance. In the middle of active proceedings, with the judge still speaking from the bench, Donald Trump's lead attorneys did the unthinkable. They stood up, gathered their papers, and attempted to walk out of the courtroom in full view of the judge, the jury pool, court staff, and packed media galleries. This was not a misunderstanding. This was not a procedural pause. This was a deliberate, calculated act of confrontation, and what followed sent shockwaves through the legal world that are still reverberating. Within seconds, the judge issued an arrest warning so severe it threatened to permanently alter the trajectory of the case. Seasoned attorneys with decades of experience do not abandon a client mid-trial unless something has gone catastrophically wrong. That is not opinion. That is legal reality. And if you think this was spontaneous anger or theatrical protest, stay with me, because what you are about to hear fundamentally changes how this moment must be understood. So what triggered a walkout that legal scholars are already calling one of the most reckless courtroom maneuvers in modern American history? Transcripts obtained shortly after the hearing show that tensions had been building all morning as prosecutors introduced evidence Trump's legal team repeatedly labeled fabricated, inadmissible, and politically motivated. The temperature in the room rose steadily, but everything detonated when Judge Patricia Caldwell issued a ruling that insiders say sent Trump's lawyers into visible panic. According to multiple observers, lead attorney Robert Sterling turned visibly pale before abruptly standing and declaring that the defense could no longer continue under what he described as a fundamentally compromised court. This was not a heated objection. This was not routine courtroom friction. 3 attorneys simultaneously attempting to exit while a federal judge was still speaking is being described by legal ethics experts as potential career suicide. If this is making sense so far, pause and ask yourself, what would force elite attorneys to risk disbarment in front of national cameras? The morning had begun with what appeared to be procedural disputes over financial documents, but sealed court filings accidentally posted to the federal docket system for a brief window revealed something far more explosive. Prosecutors had submitted new evidence just days earlier, evidence allegedly including direct communications between Trump and multiple co-defendants during a period when they had publicly claimed no contact existed. Sources say the materials included encrypted messages, wire transfers totaling approximately $4.7 million, and what one insider described as the most damaging financial paper trail prosecutors have ever assembled in a political corruption case. When Judge Caldwell ruled all 800-plus pages admissible, everything collapsed, and here is where the confrontation turned openly hostile. Court reporters recorded every word as Sterling addressed the judge before attempting to leave. He accused the court of abandoning impartiality and transforming the proceeding into what he called a predetermined show trial. His co-counsel followed, accusing prosecutors of misconduct and refusing to legitimize the process with their presence. This was not legal argument. This was institutional warfare. But the moment everyone is still whispering about came from Trump himself, or at least from what multiple sources say he whispered to remaining local counsel. According to 3 independent accounts, Trump said, "Let them arrest me. It guarantees the nomination." Whether bravado or calculation, that statement reframed the entire confrontation as political theater layered on top of legal crisis. Judge Caldwell's response was immediate and historic. A veteran jurist with more than 3 decades on the bench, she did not hesitate. She warned the attorneys that any further movement toward the exit would result in criminal contempt and bench warrants for immediate arrest. She then addressed the courtroom with words that landed like a thunderclap. "This is a court of law," she said, "not a reality show." Drop a comment right now and tell me, do you believe that line crossed the point of no return? The standoff escalated further. As the defense team continued toward the doors, Judge Caldwell ordered U.S. Marshals to block every exit. Armed federal officers moved into position within seconds. She warned the attorneys they would either return to counsel table or be remanded into custody until they were prepared to fulfill their professional obligations. The room fell silent. Spectators later said they could hear breathing. The tension was so intense that seasoned reporters described it as suffocating. For several minutes, the highest-paid defense attorneys in America stood frozen between federal marshals and a judge threatening arrest. Security footage later revealed another chilling detail. Sterling's phone lit up repeatedly with an incoming call saved under a familiar political contact name. He never answered, but he kept glancing at it. That detail matters, because what Judge Caldwell revealed next explains the panic. She announced on the record that she had received a sealed ex parte submission from the Department of Justice that very morning. Ex parte filings are extraordinarily rare and typically reserved for matters involving national security, witness safety, or classified intelligence. Based on that submission, she said, she was considering enhanced security measures and potential jury sequestration. Legal experts immediately understood what that meant. A cooperating witness had likely emerged, someone close enough to detonate the defense strategy entirely. Former federal prosecutors explained it bluntly. When defense lawyers hear about a sealed ex parte submission in a case of this magnitude, they know the walls are closing in, someone inside has flipped, and suddenly, the walkout attempt made horrifying sense. This confrontation occurred just days before Trump was expected to testify. His own legal team had reportedly warned him that taking the stand would be disastrous. Trump, sources say, insisted he needed to tell his story. Now that entire plan is in ruins. After the standoff ended and the defense returned to their seats, Judge Caldwell delivered what many are calling the nuclear warning. She stated she was considering appointing shadow counsel, backup attorneys prepared to immediately replace the defense if they attempted withdrawal again. In legal terms, this is extraordinary. It signals the court believes the defense may attempt further sabotage. The consequences are staggering. Sterling's firm has billed more than $12 million in fees and now faces potential sanctions that could reach 7 figures. Attempting to abandon a client mid-trial opens the door to disbarment proceedings. Bar associations moved quickly to remind attorneys that withdrawal after trial begins is not optional. This is not simply about Donald Trump as an individual defendant, and reducing it to that misses the far more serious institutional stakes now in play. If attorneys were permitted to walk out of a courtroom whenever rulings did not go their way, the justice system itself would begin to unravel. Trials would no longer be governed by rules, precedent, or procedure, but by brinkmanship and spectacle. Judge Caldwell made this point unmistakably clear from the bench. Allowing such tactics, she warned, would create a perverse incentive structure in which every losing party could attempt to manufacture a mistrial through calculated disruption, turning judicial proceedings into strategic ambushes rather than structured searches for truth. In that scenario, courtroom authority collapses, judges lose the ability to maintain order, and the rule of law becomes conditional on the willingness of attorneys to comply only when outcomes are favorable. The political fallout from the confrontation was immediate and explosive. Trump's social media platforms erupted within minutes, framing the incident as proof of election interference and judicial persecution. High-profile Republican lawmakers echoed that narrative almost instantly, accusing the judge of authoritarian overreach and warning that the judiciary was being weaponized for political ends. Democrats responded just as forcefully, insisting that no individual, including former presidents or their attorneys, is above the law. Cable networks looped the footage nonstop, clips spread across platforms at viral speed, and within minutes, millions of Americans had seen the images of attorneys confronting a federal judge. The spectacle succeeded in its secondary objective, generating outrage, polarization, and mass attention far beyond the courtroom itself, effectively transforming a procedural crisis into a national political flashpoint. But here is the critical detail that most viewers never saw and many commentators failed to emphasize. Within roughly 30 minutes of returning to the counsel table, the defense team filed emergency motions seeking both a mistrial and the recusal of Judge Caldwell. Legal experts are nearly unanimous in their assessment that the walkout was not merely an emotional protest or spontaneous breakdown, but a strategic move designed to lay the foundation for future appeals. By provoking a confrontation and forcing the judge to issue stern warnings, the defense created a record they can now cite as evidence of alleged bias and hostility. Regardless of how the trial ultimately concludes, appellate pathways have now been deliberately seeded, ensuring that this case will continue to reverberate through higher courts long after the verdict is read. The prosecution responded with unmistakable force, moving quickly to reassert control over the narrative and the courtroom itself. Prosecutors sought daily financial penalties against the defense, arguing that what occurred was not a good-faith legal dispute but a deliberate disruption that endangered the integrity of the proceedings. They also accused the defense of coordinating the stunt with media allies in order to manufacture a public storyline of persecution, intimidation, and judicial tyranny, a storyline that could travel faster than any legal transcript ever would. Court records and press logs show that camera crews were positioned outside the courthouse well before the confrontation erupted, and that detail matters because it suggests preparation, not surprise. In high-stakes trials, timing is strategy. Prosecutors are essentially signaling to the judge and to the public that this was not spontaneous outrage, it was a planned spectacle designed to generate clips, headlines, and political fuel. And in a case already saturated with national attention, that kind of pre-positioning is not neutral, it is narrative warfare. Then there is Witness 14, and this is where the stakes shift from courtroom drama into genuine legal danger. Department of Justice sources indicate that testimony is expected soon from a protected individual with direct access to the financial transactions at the heart of the government's case. This is not a peripheral witness. This is someone positioned close enough to see the machinery, the routing, the approvals, and the intent, the elements prosecutors need to turn a complicated financial case into a simple story of knowing conduct. The witness has reportedly been under protection since the fall, and that alone tells you the government believes there is a credible threat environment around this testimony, either because of potential intimidation, retaliation, or simply the volatility that can follow when insiders start speaking. In federal practice, protective custody is not used for convenience. It is used when prosecutors believe exposure could compromise safety, cooperation, or the case itself. That is why defense teams fear it, because it often means someone has decided to trade silence for survival, and that trade can collapse entire strategies overnight. So here is the question I want to put directly to you, because it cuts through the noise. Was this courtroom meltdown really about legal ethics and principled protest, or was it about political survival and damage control, an attempt to seize the narrative before a protected witness seizes the facts? Because from where prosecutors are standing, the defense did not just challenge a ruling, they attempted to bend the venue itself, transforming a federal trial into a stage where public outrage becomes a tool and where procedure becomes a prop. And the implications go far beyond one defendant. When lawyers treat federal trials like campaign events, when each objection is framed not as argument but as messaging, and when the goal is not merely to win in court but to win on camera, the system starts to fracture. Judges are forced into an impossible role, not just refereeing law but managing spectacle. Courtrooms become arenas where legal outcomes compete with viral moments. And when a judge must threaten arrest simply to maintain order, it signals something deeper than conflict. It signals erosion of shared rules. Justice cannot function as performance art without consequences. If trials become theaters of provocation, then the public's trust becomes collateral damage. And once that trust is lost, every verdict becomes suspect to half the country, regardless of what evidence says. As this case moves forward, the stakes could not be higher, and not just politically, structurally. Judge Caldwell is expected to rule on the mistrial and recusal motions, decisions that will shape not only the schedule but the legitimacy of the proceedings in the eyes of the public. Marshals are reportedly briefed for potential enforcement actions if courtroom order is challenged again, and even the existence of that contingency tells you how serious the court views the risk of repeated disruption. Political alliances are shifting in real time as elected officials choose sides, not always based on the record, but based on perceived advantage. Markets are watching as well, because high-profile legal instability affects business timelines, investment assumptions, and future governance expectations. And the public is being pushed into a test it never asked for, deciding whether the rule of law still matters when the defendants are powerful, when the cameras are rolling, and when the courtroom itself becomes part of the campaign battlefield. So I'll ask you again, and this time answer it without talking points. Do you believe this is a legitimate fight over fairness, or a calculated strategy to manufacture doubt, delay, and outrage before the most dangerous testimony arrives? Drop your answer in the comments. Did Trump's legal team cross an unforgivable line, or was this the only move left? Should the judge have ordered arrests, or would that have fueled the narrative further? Because this is no longer just a trial. It is a stress test of American justice itself. And what happens next will define not only this case, but how power, law, and politics collide in this country for years to come.